Hello everybody, welcome to another video from www.freedqinfo.com. In this video, I'm going to show you how the New York City Civil Service Commission defended the reversal for Mr. Ahmed. Again, Mr. Ahmed, as you recall, he received the illegal DQ letter, and over here are some couple of documents where the Civil Service Commission defends and justifies the reversal. The first part that I want to bring your attention to is how Civil Service Commission basically argues that they have the power to hear and determine appeals by any person aggrieved by any action. All right, we go to the next page. They basically talk about how the Civil Service Commission may hear oral argument. Now, this is where it gets very fuzzy and interesting, because whenever the Civil Service Commission issues a reversal, all right, they use this argument over here that they held a hearing in order to basically prove that the disqualification was illegal. But in cases where applicants filed Article 78s against the Civil Service Commission asking, hey, how come I didn't get a hearing? They basically point to the same argument and says, well, according to this rule, it says that we may hear oral argument, but we don't have to. But when you actually analyze what the Civil Service Commission has done in the past with regards to reversals, you realize that this is not true. All right, so let's look at it over here very carefully. Importantly, this regulation has been found to be consistent with civil service law and the Civil Service Commission's mission to afford those disqualified an opportunity to make an explanation and to submit facts in opposition pursuant to Civil Service Law Section 50.4, and therefore to have the force and effect of law. All right, so here they're basically justifying any hearing that they might hold for an applicant, saying it's consistent with civil service law, it's part of our mission to avoid those disqualified an opportunity to make an explanation. Okay, if that's your mission, then how come when other people have gotten illegal disqualifications, the Civil Service Commission basically decided not to hear any oral argument or to afford that applicant any opportunity to make an explanation? So this is basically very hypocritical on the part of the Civil Service Commission. Now, let's go to over here. And here, the Civil Service Commission basically argues that NYPD's decision was procedurally defective because NYPD failed to give Mr. Ahmed advance notice. So they're basically saying the DQ letter was illegal because it was not the notice of proposed disqualification. So here they say, the record indicates, and the NYPD acknowledged at the Civil Service Commission hearing, that NYPD failed to provide applicant with a written statement of reasons for his disqualification before the final disqualification was issued, and the disqualification failed to indicate the section of civil service law under which he was disqualified. We note that this deprived him of an opportunity to make an explanation and submit facts in opposition before his disqualification became final. And here it is. Here's the critical thing. This was clearly a rational basis for reversing the NYPD. So the fact that they issued the illegal disqualification letter was enough for the Civil Service Commission to reverse the NYPD, and they called it a rational reason. And it is. And that's what they argued. And in the Ahmed case, Honorable Justice Schlesinger, she agreed. She said the court agrees that the procedure was in fact defective. I'm going to take a break right here, and we will continue with this topic later.